Because we have now what is a constitutional democracy. It's a democracy in accordance with that constitution as the kingpin of all our actions. And so important is this new constitutional principle that, my Lord, Article 10 itself talks about the need for every state organ or public or state officer or public officer who applies, enacts, interprets, or implements public decisions to comply with Article 10. The proposition that my learned friend was putting before you is why everything went wrong. We had a rogue parliament that could change laws at any time. The security of judges' tenure was removed. Security of tenure of the Attorney General was removed. Parliament could do as it wished. They could change the Bill of Rights anytime. But this new constitution created a foundation that now made it impossible for institutions to act as they wish. And if they act, they must act in accordance with the law. They cannot be left alone. And this principle is so important that in Article 258 of the Constitution, states that every person has the right to institute court proceedings claiming that this Constitution has been contravened or is threatened to be contravened. Look at that. So that even an institution, before it takes any action, if there's a likelihood of a threat, then the forum is the court. I would invite the court, because of brevity of time, Article 248, 249, you would see the manner in which even the independent officers are required to be guided by constitutionalism and the rule of law. So, in a nutshell, what I'm saying, institutions, in this new dispensation, they cannot be left alone. They can't, every moment. And that's why I think there's a lot of litigation. I understand even one is coming right now. Yes, he's waiting to stop presidential debates. But having said that, just one specific thing on the account, the Attorney General told us that, you know, the Constitution is not a procurement law. If you look at the preamble of the Constitution, of the Public Procurement Asset Disposal Act. Indeed, I should start from the Constitution. If you look at Article 227, 2, an act of Parliament shall prescribe a framework within which policies relating to procurement and asset disposal shall be implemented, and so on and so forth. So this act flows from the Constitution. And right at the preamble, it says an act of Parliament to give effect to Article 227 of the Constitution. You cannot run away from the Constitution. And it was lost to my learned friends that my learned friend, Mr. Seme, had actually cited Section 3 of this act that gives guiding principles, which include A, the national values and principles provided for under Article 10. And it quotes various sections of the Constitution. including Article 232. And I want your lordships to compare this with even the requirement when it comes to security organs. You know, there was a time when, under the old constitution, we came before the courts, and we did that many times. National security would be cited as a basis of abrogation of the Bill of Rights. Now, in 238, not even the national security organs are allowed to abrogate the Bill of Rights, and they are supposed to carry their functions in accordance with the Constitution. That is all spelled out there. On the question as whether we should have gone to the procurement board, on the question of res judicata, I think the record is clear. The basis upon which this court can reach that conclusion does not exist. And my learned friends, Mr. Ngati's anxiety over why these proceedings are here was answered by Section 174 of the Procurement Act. My Lord, finally, before I sit down, two things. We are not dreaming or encompassing a situation where the elections will be postponed, that they will not be held on the 8th. They must be held on the 8th. Because our degree and fidelity to the Constitution is that the applicant is committed to the holding of the elections on the 8th of August. But there are articles under, provisions under Article 138 that create scenarios. For example, your lordships, if neither candidate gets to the constitutional threshold, that is 50 plus 1, and a majority of counties, 25% of the vote in the majority of counties, another election will have to be held, a runoff within 30 days. That will be a subject of a separate tender within 30 days. And if nobody qualifies, then an election will be held within 60 days. So it's not quite a closed shop like my learned friends are trying to say. And if you look at the affidavits of both Mr. Magaya, the first affidavit, and that of Mr. Chiloba, you'd see that the specification in respect of presidential elections and the other elections are quite different. They are quite different. Even in terms of transmission of results, they are not required under the law in respect of the elections which are held at the county level. There are 6 separate and distinct elections, but the presidential elections is very unique. And to that extent, it can be held on the same day. I think the requirement is that they be held on the same day. But not necessarily presided over by the same presiding officer or the returning officer. Not necessarily, it is not there in the law. Now, the other danger why this case is so crucial, my Lord, a reference has been made about the process in Parliament where we came up with the Election Laws Amendment Act 2016. There was an amendment to Section 234 which set out the new electoral system in Kenya, and it said that the electoral system in Kenya will be an integrated electronic electoral system. Now, after we had this agreement, which was bipartisan, there was another amendment which was brought, which essentially changed that Section 44. That is where the fear is that it is in the discretion of the respondent to determine an alternative mechanism in regard to that system. If it fails, those safety measures provided by an electronic system will be removed, because, in essence, in the discretion of the commission, like they did in the last election, when the system collapsed, they can say we go manual. And you can see in their specification that the documents we put before you, there are specs for poll registers, whereas the law only provides for one register with features and attributes, which again are biometric insofar as that law is concerned. I don't want to extend and say more than that. Just in case my learned friend might forget to deal with this, Mr. Kinyanjui's point on the orders prayed for. The decision is there. It exists. We're not talking about a decision that does not exist. It is admitted, it exists, there's a contract, there's an award. But in relation to the requirement under Order 53, my Lord, if you look at Order 53,
all right, so that's James Orengo, the lawyer representing NASA, just making another submission. Remember that today a three-judge bench has been listening for the better part of the day on that case that was filed by the opposition coalition, NASA, in regards to the ballot paper printing tender that was awarded to that company in Dubai, Al Ghurair, for